Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2 in Jefferson County, Texas. You have been asked to come to court today for what we call an arraignment. An arraignment basically is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. Your criminal case is a misdemeanor case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are referred to as your most serious type of offenses, whereas your misdemeanor offenses are referred to as petty offenses. It does not mean that they're not serious. It just basically means that they're not as serious. And when I use the word serious, what I'm referring to is the facts and the possible punishment that a person can receive if they are convicted of the crime. Now, for example, felony cases are divided into 5 categories, and we'll start at the top and go down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. Person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life, and a fine that doesn't exceed $10,000. Now, if a person is convicted of a capital murder, which is the highest felony offense, the range of punishment is life in the state penitentiary without the possibility of parole, or death by lethal injection. Now, as I mentioned earlier, your offense is a misdemeanor. You can tell that door is locked. And so therefore, you don't have to worry about those ranges of offense. Now, misdemeanor cases are basically divided into 3 categories. And we'll start at the top and go to the bottom. You have the Class A misdemeanor, Class B misdemeanor, and a Class C misdemeanor. Now, your Class C misdemeanors are cases that are actually normally held in the JP court, which is a justice court, or the city court, which is a municipal court. And if a person is convicted of a Class C misdemeanor, they only can get a fine. The fine is usually up to $500. Now, however, if the person fails to pay the fine, or if the fine is converted to community service and they fail to perform the community service, then the court can issue what is called a capious pro fine, which basically means it's a warrant for the arrest for them to sit out the fine. That's it. That basically means that they can be arrested and put in jail to sit out the fine. And normally, I think in the municipal court, you get it every day that you sit in jail in municipal court, it's $150 a day. So if your fine is $150 a day, if it's $150, then that means you don't have to sit out 1 day. If it's $300, sit out 2 days. Now, if a person is convicted of a Class B misdemeanor, the range of punishment is minimum 0 days to maximum 180 days in the county jail, a fine that does not exceed $2,000, or you could be given both such fine and confinement. If a person is convicted of a Class A misdemeanor, range of punishment is minimum 0 days to 365 days in the county jail, which is 1 year, a fine from $0 to $4,000, or a person can be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. One of the rights that you have is a right to have an attorney. And the paperwork that you have on the clipboard talks about your right to have an attorney. And I'm going to go over that paperwork with you right now. The first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. And as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. That is, you can waive your right to an attorney or give up your right to have an attorney to represent you, and you can represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset. Reset means you'll be given another court date so that you will have enough time to hire an attorney. If you want an attorney and do not have enough money to hire one, you will need to fill out a financial questionnaire. The financial questionnaire is the third document on the clipboard that is titled Jefferson County Affidavit of Indigence. You would have to fill out that document so that the proper person can determine whether or not to appoint an attorney to represent you. If you want to waive your right to have an attorney or give up your right to have an attorney to represent yourself, you may not speak to the prosecutor about your case unless you first sign a written waiver of your right to be represented by an attorney. Now, the written waiver is the second document on the clipboard. It is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Now, you would only sign that document if you are giving up your right to have an attorney and you would like to represent yourself. And if you sign the form and you indicate that you would like to represent yourself, then you'll have an opportunity to talk to one of the two prosecutors that are in court that's sitting at the table in front of you. Now, be aware that there are dangers to self-representation. That is, waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, you may change your mind at any time, and you may request that an attorney be appointed to represent you. That's what the last sentence above the line that is titled Judge Terrence L. Holmes, that's what that says. Now, below at the bottom of this document, in bold letters, it states defendant's choice. Mark your initials next to only one choice. If your choice is to hire your own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If you want to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in this case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to represent yourself, that is, if you want to waive your right to an attorney and represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines at the bottom of this document, then you will sign your name on the line that is titled defendant, and you will date it today's date, November 14th of 2023. Now, for those of you who will be waiving your right to an attorney and representing yourself, The second document on that form that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial, it states as follows. I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily meaning that you're doing this of your own free will. And it says my waiver is voluntarily and intelligently. Intelligently means basically you know what you're doing. So it states that my waiver is voluntarily and intelligently made. Furthermore, I have been advised this 14th day of November of 2023 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm able to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed to represent me. I hereby waive my right to counsel. And when they use the term counsel, they're talking about an attorney. If that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date, November 14th of 2023. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. One of those young people is sitting in that area, we call that the jury box. 6 citizens will be selected to serve as jurors in your case. They will listen to all the evidence, the arguments. They will deliberate, and after they deliberate, they can either find you not guilty or guilty of your charges. You also have a right to waive your right to have a trial by jury. Waiving your right to have a trial by jury means you have a right to give up your right to have a trial by jury. And by doing so, you will not be having a trial by jury. However, your case will come before the court in one of 3 ways. One way it can come before the court is by way of a bench trial. When I use the term court, I'm saying before the judge. It can come before the court by way of a bench trial. A bench trial is a trial by judge only. You don't have a jury, you just have the judge. And the judge will listen to all of the evidence and the arguments, and then the judge will decide whether to find you not guilty or guilty of your charges. The second way that your case can come before the judge is by way of an agreed plea bargain agreement. A plea bargain agreement is a settlement that you have worked out with the state to settle your case. If you are able to come to a plea bargain agreement with the state, then your case will come before the judge. The judge can either accept or reject the plea bargain agreement. If the judge rejects your plea bargain agreement, then you can take back your plea. And that's when you can withdraw your plea. For example, let's say you and the state has worked out a plea bargain agreement, and the plea bargain agreement is for you to be placed on probation. And the judge say, well, I'm not going to follow that plea bargain agreement. Then you say, you can tell the judge, well, judge, I withdraw or I take back my plea bargain agreement. And so you can do that if the judge does not accept your plea bargain agreement. Now, if the judge accepts your plea bargain agreement and you decide within 30 days that you would like to appeal your case to a higher court, in essence, you would like to have a higher court to look at this case because you think you've been wrongfully convicted or the court committed an error by convicting you. And if that is the case, you have to get permission from the judge to appeal your case if the judge followed the plea bargain agreement. Now, if the judge gives you the permission to appeal your case will go to the 9th Court of Appeals, which is located right above us on the 3rd floor. They will review your case. They could either grant or deny your appeal. If they grant your appeal, they can simply find you not guilty. or they can send the case back down to this court, or to this court to give you a whole new trial. If they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeal. You can appeal it to the Texas Court of Criminal Appeals, located in Austin, Texas, and it is the highest court, it's the highest criminal court in the state of Texas. You will have to file what is called a pro se petition for discretionary review. Pro se means you'll be filing this petition without a lawyer. You'll be doing this on your own. They call it a pro se petition for discretionary review. You'll be asking the Texas Court of Criminal Appeals to review your case, to see whether or not your appeal should have been granted, to see whether or not this court committed an error by convicting you, or whether or not you have been wrongfully convicted. The Texas Court of Criminal Appeals can do one of two things. They can either grant or deny your pro se petition. If they grant your pro se petition, they can simply find you not guilty, or they could send the case back to the Ninth Court of Appeals, order them to answer some questions, or they could send the case back down to this court and order this court to give you a whole new trial. Or if they deny your appeal, at that point, your conviction will stand. Now, the other way that your case will come before the judge, besides a bench trial or an agreed plea bargain, is by way of an unagreed plea bargain agreement. What that means is you talk to the state, to the district, assistant district attorneys, and you've been unable to work out a plea bargain agreement. And so you want the judge to decide what your punishment will be. We call that an unagreed plea bargain agreement. Now, as a defendant in a criminal case, you also have a right to have witnesses to come to testify in your trial. You have a right to call witnesses. And witnesses sit in that chair right there that we call the witness stand, the chair with the microphone. They can testify either for you or against you. Represented by an attorney, or you're representing yourself. Questions can be asked of the witnesses. We call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses to come to court. If you waive or give up the right to have witnesses to come to court, what that basically means is you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because the state will be calling witnesses in the case that they have against you. You also have a Fifth Amendment right against self-incrimination. What that means is you have a right not to testify in your case. So if you invoke your Fifth Amendment right against self-incrimination, the state cannot call you as a witness in the case. Now, you can waive or give up the right to invoke your Fifth Amendment right against self-incrimination. If you waive your Fifth Amendment right, that means if you give up your Fifth Amendment right against self-incrimination, you will be testifying in your case. You also have a right to have what we call discovery. Discovery means you have a right to see the evidence that the state has or that the state will be using against you. You have a right to see the documents, witness statements, your statement, police reports, lab reports. You have a right to see video recordings, have access to audio recordings, and in any instruments that the state have, you have a right to have access to that evidence. Now, you can waive, which means you can give up your right to have access to that, and by doing so, if you waive or give up your right, you would not be having access to the evidence that the state will be using against you. Now, everyone that's here on for arraignment, you have been arrested, placed in jail, you bonded out. You're either out of jail on a cash bond, which means that you paid the full amount of the bond to get out of jail, or you're out of jail on a surety bond, which means that you paid a percentage of the bond to a bondsman to get out of jail, or you are out of jail on what we call a pure bond or a personal recognizance bond. That simply means that you did not pay any money to get out of jail. You were released under your own personal recognizances with a promise to appear in court for the court dates. Every day that you spent in jail, that jail time can be used as credit towards your punishment. So for example, let's say you spent 5 days in jail and you and the state have reached an agreement, and the agreement is, the plea bargain agreement is that you will serve 5 days in jail. Well, that simply means that you will not have to serve any more time in jail because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you have already served. Now, if the state is offering 7 days in jail and you serve 5 days in jail, that means you only have to serve 2 days in jail because you already have credit for 5. Every day that you spent in jail can also be used as credit towards your fine and your court costs. So, for example, you spent 5 days in jail, you normally receive $100 per day that is credited for the time that you spent in jail, each day that you spent in jail. So, for example, if you spend 5 days in jail, that's $500 credit that can go toward your fine and court costs. The state is offering you fine and court costs of $500. That simply means you will not have to pay anything. Why? Because the 5 days and days you have spent in jail has already paid off the fine and court costs. Therefore, you will the fine and court costs will be taxed and retired. Now, if they're offering fine and court costs of $700, that simply means that you would have to pay $200 because you already have $500 credit for the 5 days that you've already spent in jail. If you cannot pay the $200, then we can put you on what is called a payment plan, which means you can be required to pay off the $200 in monthly installments over a period of time. Now, if you are still unable to pay off the $200 because you do not have the income to pay off the fine and court costs, no problem, because the court can convert your fine and court costs to community service. You receive $12.50 for every 1 hour of community service that you perform at a nonprofit organization in the Jefferson County area. Jefferson County District Attorney's Office has a program that is called pretrial diversion. It is for first-time offenders. If you have not been in trouble before, this is your first time getting into trouble, then Jefferson County District Attorney's Office will dismiss your case. And once you're in the program, your case is dismissed. If you complete the program, then you can get the case expunged from your record. Expunged means wiped off, deleted, or erased from your record. Now, in order to qualify for the program, you have to get an attorney to assist you in getting in the program. It cannot be for an offense involving resisting arrest or unlawfully carrying a weapon. And as I mentioned earlier, it has to be your first time getting into trouble. If you are a veteran of any one of the branches of the United States military, Jefferson County District Attorney's Office also has another program that is called Veterans Court. It is a program for veterans only. With that program, like the pretrial diversion program, once you get into the program, your case is dismissed. And with this program, you can get what is called, if you complete the program, you can get what is called a non-disclosure. A non-disclosure basically means that your record is sealed from the public. It does not mean that the government, now the government can have access, but the general public cannot have access to your criminal record because your record is sealed to the general public. This court has a program that is called the CSI program, stands for Community Safety Initiative. It is a program that I started within the first 100 days of taking office. With that program, the program is designed to address the issue of what is called recidivism. Recidivism basically is people committing crimes over and over. And the way we address recidivism, we have a partnership with some local agencies. One of the local agencies that we have a partnership with is the Spindletop Center. The young people that I pointed out earlier, they're from Spindletop. They're going to come to you in a little bit and tell you more about the program that Spindletop has to offer. But generally, the Spindletop program, what they will do, they can do a private interview. They can do an assessment, develop a treatment plan for either outpatient or inpatient treatment. And as I mentioned earlier, they are a local mental health center. You do not have to be incompetent or insane to participate in the program. You can just simply have issues with anxiety or depression or any other host of mental illnesses. Spindletop has the expertise to address your mental health needs. Now, if you have problems with drugs or alcohol, whether or not you admit it or you're in denial, Spindletop has a program that is called ATAR. ATAR stands for Addiction, Treatment, and Recovery. Our local drug and alcohol council has a program that is called OZAR. OZAR stands for Outreach, Screening, and Referral. Both of those programs are drug recovery and alcohol recovery programs. And what they will do, they can do a private screening, an assessment, and they can develop a treatment plan, either outpatient or inpatient. If you are unemployed or if you're looking for a better job, then we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained at any one of the jobs or any one of the areas that you select, they will assist you at getting a job in the area that you're trained in. If you have not finished high school and you would like to get a GED, CICE has a GED program. Now, all of these programs that I just mentioned to you are free. It does not cost you anything. Only thing it basically costs you is just the minimum amount of time to participate in the program. Now, with the programs that I mentioned earlier, these programs are not, it doesn't cost you anything. They are free. And with these programs, in County Court at Law number 2, we do not just arrest the problem, we address the problem. And that basically means that we do not just give time, we take our time. And we believe that by taking our time, we can produce productive people. And if we produce productive people have too much to lose. And so therefore, they will not be committing crimes. Therefore, I like to say in this court, we don't have court as usual. We have unusual court. And it's not because we're different, because we're trying to make a difference in the lives of the individuals that comes before this court. And if we make a difference in the lives of those individuals that come before this court, we will make a difference in their home. And if we make a difference in their home, we will also make a difference in the community in which we live, because what comes out of the home goes into the community. So if you're interested in any one of these programs that I just mentioned, just let us know. We have some brochures that we can give to you, and so that you can get in contact with the individuals who are over those programs. So as I mentioned earlier, we have individuals from Spindletop, and they're going to come before you now and tell you something about the Spindletop program that we have. We have Gabby and Deputy Hinton. You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state commission here with the sheriff's office. This is my co-worker, Gabby. Now, Gabby is a qualified mental health professional to spend time. The reason we are both here is because the judge has graciously invited us in this courtroom because he cares about every single person who comes before his pen. What the judge has found, it's proved, is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources to help you with your particular situation.
So being in the court, we can understand doesn't help any real life situations right now. It can cause extra stress on your life also. This can be financially, mentally, emotionally, even physically. And so we understand that it doesn't help being in here, help your life situation. So we come here and we try to help you as best as we can. And by providing, see what resources we can help you with, and we can, even if it's not what's been the top, we want to connect you with resources that you can.
Now, maybe this is your first time to be here, maybe it is your 10th time to be here, there's still hope. In fact, what we're offering you today has the ability to change your life. But we're gonna need something from you. We need you to share that need with us so we can best figure out how to get you connected with the resources that will help you with your particular situation. Now, Gary's gonna explain how you can do that very privately. We're not here to embarrass anyone. This document that she already handed out to you is gonna be the start, but she'll explain to you exactly what we will do with that document and how we'll use that to benefit you.
So with this document, it is HIPAA regulated, so just like yeah, I'll give you one. Yeah, gotcha. Just like your medical information is protected, this is protected also. I'm the only one who's gonna see this, I'm the only one who's gonna be contacting you. It's not gonna be a robocall or anything like that. It's gonna be from my work phone. It's gonna, initially it's gonna be a text message. If you don't receive text messages, you can just communicate that to me and I can give you a call. After that, I can contact you once and then just one text message. If you don't want to receive any more text, it'll just be that one time. I won't add you or anything like that. The most important thing that I need on here is a phone number for me, a good phone number that I can reach you at, and also a way to share which resources you want. You can do the check boxes right here. It's pretty broad for a reason, but if you want to specify, there's a space right here where you can fill in also. And if you do want to talk to me privately today, you can check the bottom of it and we'll talk privately outside. If you have any questions for me, you can also just tell it on the phone.
Also, before you leave here today, I want to get this flyer in your hands. It tells you a little bit about some of the advantages of actually participating, but it also has a 1-800 number on there. Should you find yourself in an unsafe place, you can call that number and get help immediately. And just shortly, the court is going to go into recess. When it does, we'll be able to come out there. We'll pick up those forms from you. I'll be handing this out to everyone as well at that time.
Thank you.
Thank you very much. Thank you, Your Honor.
Thank you, Deputy Henry and Gabby. Now, ladies and gentlemen, the paperwork that you have on the clipboard, we're going to pick that paperwork up from you. If you need any help at filling the paperwork out, we have our court personnel who's here, who will be available to help you with filling out that paperwork. Now, in order for us to pick up the paperwork, it's going to take us a little time. It's not going to be that much time. But in the meantime, if you need to use the restroom, there are 2 restrooms right outside in the hallway. The men's restroom is in front of County Court at Law number 3, and the female restroom is across the hall in front of 172nd District Court. Now somebody, if you can't have your phone on in the courtroom, I think I heard something, make sure your phones are off. And now, as I mentioned earlier, if you use the restrooms, you come back into the courtroom. Do not leave the courthouse because we're not finished. We're not finished with your case. If you leave the courthouse and we call your name, you're not here, your bond is going to be forfeited. If your bond is forfeited, that simply means a warrant will be issued for your arrest, and you'll be arrested and placed in the Jefferson County Jail. All right. So, in order to avoid all of that, it's just going to take us a few minutes to do what we have to do. And then once we get all of the paperwork, we're going to call you up before the bench, one person at a time. You'll stand before the bench. And then once we finish here, you're going to go to the court coordinator. And then she's going to give you your paperwork that you need. And then you'll be able to leave. the courtroom. At that point, your case will be over today. Your case will be reset. Now, for those who will be waiving your right to have an attorney and you're representing yourself, you'll have an opportunity to talk to one of the two prosecutors that are here in court. Okay? So at this time, ladies and gentlemen, the court will be in recess, and the folks from Spindletop is also going to come out and talk to some of you. All right? Court is in recess.